All right. So again, good morning, everybody. My name is Patrick Fife. I'm LIBOR's general counsel. A lot of things to cover today. Couple new things, couple updates on things. So hopefully everybody's ready, had some coffee because I'm going to go pretty quick, just because there are a lot of things to go over. And before I get into everything, like I always do when I start, I just like to remind everyone out there, especially those of you who are new, have never taken a class with me, my number one thing that I want all of you to do, if you don't do already, is make sure you've signed up for LIBOR's emails. Go to lirealtor.com. And in particular, I want you to get the Thursday email. That is the one that has a lot of information about events, but also has our legal tip that we put out every week. And a lot of what we cover today has been addressed over the last couple of weeks. So hopefully you are getting it, but that's the number one way that I recommend that you can have a system to stay on top of all the changes that happen out there. I mean, the rate at which things happen in this industry is somewhat insane. You just got lawsuits, changes to laws, new laws, industry changes, and I really encourage you to have a reliable way to make sure you're staying on top of those changes so that you're in compliance, because it's great you're here and taking this class, but you really need to have a system that keeps you updated once a week or at least once a month, and that's why we give that to you, and hope you take advantage of it. If you're a broker or office manager, every quarter we do a risk reduction webinar. The next one is Thursday, April 2nd. So please sign up for that. It's just for brokers and office managers. You can sign up on the website. And again, this class is given for free once a month. So I see a couple repeat attendees. That's great. We like that you come every month. You're welcome to it. And I do try to change the content as often as I can. Also, check out the website, lirealtor.com. All of the legal tips are there. So you can, if you miss the email, you can go and take a look. If you need something for reference, go there. A lot of other great information. Take a look. Spend some time on that website. It's updated regularly. Events, one that I do want to make sure you're all aware of, and I'm going to just drop a link in the chat if you want to sign up for it. We do a fair housing training conference. This will be the second year we've done it with Long Island Housing Partnership. This year it is at the Esquire at the Nassau County Bar. It's $10. It's 3 hours of fair housing CE. It's breakfast, it's networking. The panel that we have lined up this year has some of the top speakers at the state level from Division of Human Rights, but also at the national level. We're going to have some people talking about AI and fair housing. I'll talk a little bit about AI today, but really some practical guidance concerning the use of some AI tools that many of you probably are using. You may not even know that they're AI, but that there are fair housing concerns associated with that, and some pitfalls to be aware of. Talk about lawful source of income, some changes or some attempted changes at the law, which I'm going to talk about today, but we'll go more in depth on that. I think it's going to be a great program. It's $10. It includes, like I said, breakfast, networking. So please sign up. I know we've got a good capacity there, but it's going to be a great event. So hopefully you sign up for that. And again, I put the link in the chat for you. Last point, just if you have questions, please feel free to take advantage and use the Legal Support Center. The number is 631-661-4800. It's extension 335. Staffed by a very qualified attorney who can, assist you in providing kind of general guidance on real estate matters. He is not there to be your attorney, but he can certainly, provide you guidance on matters, let you know what the law is on particular subjects. So please make sure that you're aware of that. I see there's a question about the link. It's right above somebody. I put it in there. Dawn, maybe someone else can post it again later, just in case people missed it. Um, so I mentioned the Legal Support Center, and I usually start off by saying, what are the most common questions that come into the Legal Support Center? But I'm going to start today with, what do you think the most frequently asked question is by people who call the legal support center. Folks, you members call up. Um, what do you think the first question the legal support center asks the callers? The attorney picks up the phone. What do you think he's asking people? The most common question that he asks the members who call. Anybody in the chat want to take a shot? I did this at a live class a few weeks ago and no one got it. Maybe a few of you were there. So if you cheat, I don't see anybody. Are you a licensed realtor and who is your broker? No. LIBOR number. He does. All right. So he does ask you for your LIBOR number. Yes. Not that question. There's another question that he asks. Nobody's got it yet. So first question that he usually asks is, did you speak to your broker? Um, Believe it or not, the answer is usually no. And this is really when an agent calls. Brokers obviously, but agents call. If you are an agent, you should be speaking to your broker about potential issues. You should be, checking in with them to ensure not only, tap into their knowledge, their expertise, but also brokers have company policies. Most brokers do. The legal support center can't give any guidance on those. Every brokerage has a right and to set their own company policy. Um, we do not provide legal advice on those. And the broker is required to provide guidance, required to provide support. And also the broker owns the listing, right? So at the end of the day, the money aspect of things, it's the broker's money. The broker is the only one that can collect the commission. I'll talk about it later. The broker is responsible for advertising. Brokers have to approve advertising. So we get agents who call up sometimes asking questions about things in their advertisements, and they never talk to their broker about it. The broker has to approve advertising. So you absolutely need to be speaking to your broker. Duty of supervision. This is required by law. The broker has to be the one providing regular, frequent, and consistent personal guidance, instruction, oversight, and superintendence. So, brokers and office managers should be making their agents aware that, hey, if you have a question, legal question in particular, you should always be checking with me. Certainly not discouraging a call to the legal support center, but it's extremely important for agents and brokers to have communication on key issues, important issues, legal issues that come up. Also, I mentioned this legal support center gets a lot of questions from agents about advertising, but those should always first go to the broker. The broker is required by law to supervise and approve all advertising before it goes live. I know that it's kind of, a lot of agents out there are independent contractors, and that's true. But by law in New York State, the broker is the only person who is permitted to advertise. This is right from the law. Only a real estate broker is permitted to place or cause to be published advertisements related to the sale or lease of property. You can, as a associate real estate broker, a salesperson, post, but that advertisement needs to be approved by the broker. So I know it's something that you don't really necessarily think about, but that's the law. So that's why that question's asked frequently. In particular on important issues when it comes to collection of commission, advertisement, legal questions. Make sure if you're an agent that you are communicating with your broker. All right, so now we'll move to what are the questions members are asking? What type of questions have been coming up recently to the Legal Support Center? And we'll run through a couple quick before we then talk about some specific topics. We do get a lot of questions, like I said, about advertising. What are the rules regarding using a title on your business card and in your advertising? Well, you always want to make sure that you're using your correct license title. Do not just call yourself a real estate agent if you're a salesperson. Don't say you're a licensed realtor. We want you to promote that you're a realtor, but you need to have your title that's on that license, that's on your pocket card. So you're a real estate salesperson or a licensed real estate salesperson. That's what you need to use in your advertising. Brokers, it's a real estate broker. That's what your title is. That's what your license title is. That's what you should be using. Really important for websites. If you are a real estate broker, make sure that everyone is identified properly. Because ultimately, what did I say at the beginning? Who's responsible for advertising? The broker, right? So if the broker's website identifies all of their associated licensees incorrectly, each one of those can be a potential fine. Also, this one's important here. Associate brokers and salespersons, you're not permitted to advertise yourself as a corporate officer. I've seen this a lot in the commercial context. Associate real estate broker might say, I'm the vice president of sales. Can't do it. Um, you just can't. You have to have an ownership interest or be the broker of record in order to use a corporate title. And just be careful with nicknames. Full license name also has to appear in addition to a nickname. This comes up a lot too. Questions about your office address and phone number. Um, Advertisements, right? And advertisements is everything, anything on the internet, even on social media. If you have a page that you use to put advertisements, you need to have the name of your broker and either the full office address or the telephone number of the brokerage, one or the other for advertisements. Business cards, you have to have both. Business cards, you need the business address and the office telephone number for the brokerage. Just make sure, the one on ad, I think most of you, we try in new member orientation, which is, when we expect most of you to kind of be getting business cards, we do go over that. But just remember on top that with advertisements, you always need either the full address or the office telephone number. All right. This question comes up a lot, and I do think we're going to try to work on developing, there's guidance on our website within the legal tips, but also we're going to try to work on maybe putting out more guidance, maybe even courses specific to this. But questions that come up, when you're dealing with estates and taking a listing from an estate, and you get that call from, the daughter of someone who passed away, the son of someone who passed away. And they say, I'm going to be the executor. It's already in the will. I want to list the property as soon as possible. And you can't take a listing from the proposed executor, even if they tell you, oh, I'm the son and there's no other siblings. I have no one's going to challenge this. It's not going to be a problem. And I've got the will. Well, that's not enough. You still need the court, surrogate's court, issues a document called letters testamentary that confirms that person has been appointed and has the power to act for the estate. So you always want to request copies of what's called the letters testamentary if it's a will. Letters of administration is the other document, and that's if somebody does not have a will. And that's before you enter into a listing because you want to verify that you're dealing with the court-appointed person. And if the court has not appointed that person, you should tell them to speak to an attorney as soon as possible. Bottom line, I mean, otherwise you don't have a valid listing, which means that you don't have a right to collect commission. And if it gets to the contract stage and these things don't exist, you're not going to have a contract. So you always want to verify that you have and are dealing with the person who has the legal authority to act on behalf of an estate. Um, Question: Can a listing broker with an office exclusive refuse to allow buyers agents to view the property? So you're saying I have an office exclusive. I haven't even advertised it anywhere. I have the seller's permission for an office exclusive, but somebody did learn about it and they want to see it. You can't hide it. You can't refuse to allow a buyer broker to view the property with the buyer. New York Department of State says the buyer always has a right to be represented by a broker at all times, including viewing the property. And so you can't take an action that would impede the buyer from having representation. Um, I see a question from Shira. I'm just going back. Sorry. She said, what about when there is no will? So if there is no will, it's called letters of administration, also issued by the surrogate's court. So you do legally, if somebody dies without a will, somebody has to petition the court to become the court-appointed administrator for an estate. And again, there's more. If it, I don't want to, I could spend a lot of more time on this, and there is guidance on our website on the legal tip. You can certainly call the legal support center if you have further questions, but you would absolutely want to speak with your broker as well and possibly counsel when questions come up concerning whether you have the appropriate person acting on behalf of the decedent. All right. Can I do a co-exclusive listing of a property with another listing broker? I've covered this a couple different times, but this question came up twice last month. So it could be a situation where, often in a divorce proceeding, right? You have a husband and a wife, or two, spouses who disagree. One wants their friend, the other wants another person's friend. They don't trust each other at all, but they want to sell the property. So they both want to have a broker who's representing, the kind of them on the sale. Um, so the answer is yes, you can absolutely do that, and it could be a lot of aggravation when you have two owners who disagree. Maybe they just don't trust each other. They don't trust the person that the other wants to hire. So it can be a very good solution. Um, the MLS one key rules do allow for it. It's Rule 317. Um, but you have to submit a co-exclusive listing agreement that identifies one of the brokers to be the listing input agent. So you can't have two separate listings on the MLS. You can't have two people identified as the person that has the ability to input the listing. You agree that one will be for the purposes of the MLS, be the listing input agent, and that listing can only be entered once in the MLS. You can't have two different listings for the same property at the same time. If you get questions about this, you can reach out to MLS customer service. They can provide some more guidance on that, but I know that is a question that comes up every so often. This one's an easy one, I think, but question comes up a couple times a month. Agent calls up and says, I'm moving to a new firm, and I want to take my listings with me. What do I do? You can't provide specific guidance on how to interact with your broker, but in New York, the broker owns the listings. Associated licensees do not own your listing. I know a lot of agents out there think it's my seller, my buyer. Well, no, it's the broker. You're working for the broker. You're extension of the broker. So it is actually the broker's listing. The broker is the one that has the contract with the seller. So unless you, as the agent, have an agreement within your independent contractor agreement or some provision, you can't take current listings or with you when you leave your brokerage. You can certainly by agreement do that, but as a matter of law, just without anything, in your independent contractor agreement, you cannot take your listings with you. And you certainly can't enter into a new listing agreement with a seller knowing they already are in contract or have a listing with your current broker. Um, Same thing, buyer clients. Nancy, good question. It would really work the same way. The buyer client signs a buyer representation agreement with the brokerage. So, if an agent leaves, certainly a buyer can voluntarily leave. If it's a non-exclusive, they can go off and work with anybody at that point and work with a new brokerage. But if there's an exclusive buyer representation agreement that a buyer has with a broker, and the agent who is working with that buyer decides to leave, they would not be able to solicit or take away that buyer. That buyer has a contractual obligation with the original broker. So it would work the same way. I think on a non-exclusive basis, that buyer has the right to work with anyone. They're not, committed or wed to the original broker. So in that instance, I think if the buyer wanted to, they could go somewhere else, because there wouldn't be interference at that point either. It's a non-exclusive relationship, but certainly an exclusive buyer representation agreement would be the same way. All right. Next, I want to talk about illegal rentals. What do you do? A rental isn't legal. Um, I think this should be an easy answer, but again, a question that does come up. Run. If it's not legal, don't put it on the MLS and don't show it. All right, period. This applies too if you're representing a prospective tenant and you learn that the property is not legal. Um, I would say I don't even want to show it to you because it is not legal, and make sure that you document in writing that you've advised the prospective tenant that this is not a legal rental. And why am I saying this? Well, Department of State says, you need to have a working knowledge of the property. And so marketing an illegal unit could violate the competency requirements, and it could invalidate your right to a commission because you're technically, facilitating the engagement of an unlawful contract, the lease of an illegal unit. So yeah, Janet, absolutely walk away. I would say run away. You don't want to be involved, period. Certainly you can work with if it's a landlord, you can assist them in letting them know what they might need to do to make it legal, point them in the direction of the municipality, whatever it is that they need. But don't list it. Absolutely. Get away from it. I think this is the last one before I move on to our next topic, but you probably have seen emails from other entities. A lot of title companies have sent emails about this attorneys, this new FinCEN rule, it's called, and what does that mean? Well, starting March 1st, so this month, the Financial Crimes Enforcement Network, that's FinCEN, it's part of the federal government, it's part of the Department of Treasury. They said that certain professionals, real estate professionals involved in closings, and this is usually the closing attorney or the title companies who are the settlement agents, have to report information about certain all cash deals that are made by legal entities, so corporations or trusts. So this would apply to all cash purchases made by corporations, trusts. Real estate licensees are typically not reporting persons. So this is not something that directly applies to you. You're not typically the person who is involved in, the actual settlement of closing. But I just do want to make you aware that, if you have a buyer in this situation, that is a corporation, an LLC, a trust, and it's an all cash deal, you should make them aware that there may be or there will be additional information that they are going to have to give to their closing attorney. And you should direct them to speak to their closing attorney about that. That way, there's no delay in the deal moving forward. Doesn't prohibit these kind of transactions at all. It's just additional reporting that needs to take place, period. Okay, I want to give you an update on lawful source of income discrimination. I'm hoping those of you that get LIBOR's emails did see we put out a couple alerts, one at the end of last week, one at the beginning of this week. We also addressed it in the legal update, I'm sorry, the legal tip for this week, but there have been some legal, not changes yet, um, but there have been some legal developments concerning lawful source of income, and I want to let you know what they are. So back up just a second. First, what's lawful source of income? Hopefully, everyone knows this because we've done so much education about it. It is a protected class in New York. It's a protected class locally. It's been so since 2019. And it does not mean that a housing provider can't ask you about income. They absolutely can. They can ask you, what's your income? How much is it? Where does it come from? What's your documentation? That's all legal. They can ask that, right? Um, what they can't do is treat different sources differently. They have to accept all lawful sources of income and treat those with different lawful sources of income equally. I don't know, 2 months ago, someone asked a question about, well, what is a lawful source? Well, it's any income. I'll go through what they are, but I certainly if you if a prospective tenant admits that they received their money from criminal activity, that's not lawful source of income. But anything else, any of these things are considered lawful sources of income. Um, uh, Anthony asked a question, can they ask what percentage you're responsible for? You're skipping ahead a little bit, Anthony. Let me get there. All right. We're going to talk a little bit about this, but lawful source of income includes all of these things. So it includes also, I don't have it up here, but income from a job. Or even from being an independent contractor. So if somebody asks you, I need documentation to see, what your earnings were last year. Um, but all of these other forms, child support, alimony, and the issues that where we see problems in the industry typically come from housing choice vouchers, Section 8, other kinds of public assistance. Those are income. They need to be accepted as income. You can't say, I like someone who has a job and gets their income from that job better than someone who gets their income from any one of these other sources. That's discrimination. It's no different than me saying, I like so and so better as a tenant because they are a woman or a man or this religion or this color or this race. It's the same thing. It's discrimination. So that's what lawful source of income discrimination, is or is as a protected class, what lawful source of income is. Well, there was a recent case, and it was just in the last 2 weeks, that was decided here in New York by a court called the Third Department. It's an appellate court. It's up in Albany. They issued a decision and said lawful source of income protections can't be used to require property owners to participate in Section 8. They didn't say all lawful source of income discrimination is wrong or illegal, but they said with respect to Section 8, it's not constitutional because it forces the owner to consent to a warrantless inspection and provide access to records. So, court effectively said, landlords can't be forced into, allowing inspections of their units for Section 8, or they can't be forced to provide access to certain records concerning the unit. So this is what the third department said. So for now, and this is the warning I want to give you, this ruling doesn't change anything. All right. You may have read about it. I saw it in the Real Deal. There was other publications that mentioned this decision. It was reported on some news channels. It doesn't change anything. Why? The New York State Attorney General, who is handling the case for the state, Letitia James's office, appealed this decision to the New York State Court of Appeals. So, from a legal standpoint in New York, if the state or a municipality appeals, it stays everything. It just puts the ruling on ice and says until the Court of Appeals or the next appellate court, in this case, the Court of Appeals, makes a determination, the ruling has no effect. So that's what's happened here. So this determination doesn't change anything for you. The law in New York remains that lawful source of income is a protected class at the state level, at the local level, including all protections for Section 8. Has not changed everything. Um, Karen just asked a good question. When will they figure this out? Um, I can't give you an exact answer. So I will say the New York State Court of Appeals, which is our highest court in New York State, they move a heck of a lot quicker than the lower court, the Supreme Court. I know for any of you that have ever been involved in litigation here in New York, it can take years, right? 3, 4, 5 years or more to get a case resolved. The Court of Appeals in New York only hears, I don't know, I think it's between 100 and 200 cases a year. It's not many because it's very limited what they could hear. One of the things they can hear is constitutional issues, which this is, and is an automatic right of appeal. So my guess is it will be at some point, maybe this year, that this gets heard by the Court of Appeals and we get a decision. I don't expect this to be something that goes on for a real extended period of time. Um, so what will happen is the Court of Appeals will either say, third department, you're wrong. This is not a warrantless search. Everything remains the same. Court of Appeals could say, no, third department, you're right, meaning they uphold the decision. But even if they do that, it would really only say that these Section 8 programs that require an inspection, that forcing or requiring a landlord to, accept or those tenants, um, that would be unconstitutional. And even then, Section 8 programs, housing choice voucher programs, or any other program that requires an inspection, they may make adjustments and say like, all right, well, we'll change it. So, um, there's kind of a to be determined here, but for now, and I think that's why the law is a good law that when the state appeals something like this, everything is stayed. So for right now, everything remains the same. There's no changes. So you need to continue to follow the source of income laws. All lawful source of income laws remain in full force and effect. There's no change here. I'm just giving you the background so you understand, why you may get questions about it, or you may hear people in your office. The ruling does not prevent or pause enforcement. I know, I think Department of State has already made that clear. I encourage you to go to that fair housing training we have in a few weeks because Division of Human Rights will be there. I think they're going to talk about this and what the state's position is and what the state might do if the Court of Appeals rules against them. So I do just want to talk about, well, why is it important that you continue to follow lawful source of income laws, and what does that mean? So why is it important? Here's just some examples. Undercover testing, it has continued and I think will continue um, to look at lawful source of income violations. Why? It's a very easy test. It's just a phone call, right? All testers need to do is call property owners, apartment complexes, real estate licensees, and essentially say, hey, I'm a prospective tenant that has a voucher. Can I see this apartment? And depending on the response, and we'll look at some of the responses that would constitute a violation, that's all a test needs to be done. So, there is a lot of testing. There will be testing. And the other thing is Department of State has zero tolerance. Department of State, if they find a violation, they are going to seek license suspension or revocation. They feel that there's been enough education about this, enough about this in the news that everyone should understand that lawful source of income is a protected class. Um, Shira has a question. Is Section 8 valid on a seasonal rental? Well, seasonal rental, it's not just Section 8 being valid. I mean, lawful source of income applies to all properties. So you can't discriminate in respect of any leasing, even if it's a seasonal rental. Whether Section 8, on a particular would cover a seasonal rental, I mean, I don't know. It's a question for the particular program. I mean, if somebody called me and said, I have Section 8 and I want to see a seasonal rental, I would say, well, does the program cover that? If they don't know, I would show them the unit and then, have them contact the program and see if the program is going to cover it. I My guess is it may not, but I would not want to make that guess. Again, I would treat this person like any other prospective tenant, and go from there. Um, Again, a lot of these are program specific questions, but I would not exclude anyone from seeing any apartment unless they said, look, I know my voucher is not going to cover it. That's different. Then they don't have the income to qualify. Same thing if someone calls up and says, well, I'm calling about an apartment that's $8,000 a month and I have a voucher that limits me to $2,000. Well, then they don't have the necessary income at that point to cover that apartment. But typically, someone who's calling as a tester, that's not the scenario that they're going to present. The testers are not there to fool people or trick people. They're calling up with legitimate situations where somebody has a voucher that covers the rent. And again, I just keep pointing to these examples that are out there. This was just at the end of December, Fair Housing Justice Center, which is a not-for-profit, did some testing. People posing as renters. Some said they had employment-based income, and some said they had vouchers. And those people who called up, the same person got completely different responses. The people who called up and said they had vouchers either got ghosted, meaning they got no response at all, or they were just said, hey, this landlord doesn't accept vouchers, which that's discrimination. Um, so all of these types of responses, that's what I mentioned earlier, constitute discrimination, period. Making any of these types of statements, I don't work with voucher holders, the landlord doesn't. Even saying, well, I have to find out. You as a real estate licensee, you can't take a listing. If a landlord says, I'm not going to work with voucher holders, then you need to tell them, I can't work with you. I have an obligation to follow the law. That is my obligation. So making any of these kind of statements would constitute discrimination. So what do you do? I think it's easy. You should and your office should have just a standard procedure for every prospective tenant that calls. This doesn't have to be tailored like, oh, well, what do I do if someone calls and says they have a voucher? It's really simple. Do the same thing you would if somebody calls and says that they have income from a job. It's the same set of questions, right? No matter and that's how you treat people equally. You have a system that treats every single person the same way. Um, you ask them, what area are you looking? How many bedrooms are you looking for? What is your price range? And you don't turn away someone because they have assistance. You would show voucher holders the same apartments you would any other prospective tenants. I'll talk a minute in a minute. I see a question about if a voucher participant has additional income or if really that would only be relevant in the situation where the voucher doesn't cover the full amount of the rent. But I'll answer a couple of these questions I see in the chat coming up. And so mentioned this already. What if the owner says, I'm not going to accept vouchers or subsidies? Just period. That's their statement. I'm not going to do it. Well, then you can't work with them. Um, the best decision you can sometimes make is not to work with someone. That was advice that was given to me even as an attorney by one of the first partners I ever worked for. If you have reservations or you have a prospective client that says, I'm not going to follow the law, you run away from them. There is no obligation to work with that person. You should not put yourself at risk. Earning a single commission is not worth the risk of putting yourself out of business and losing your license. There are plenty of other fish in the sea, and you are much better off walking away from that person. All right, so here this question, Nancy just asked it. I see a couple other questions. What about credit checks and income? And this is not intended to be a whole course on lawful source of income or a summary of it, but this question, since it does come up a lot. So let's just say the voucher covers 100% of the rent. So I'm the agent or broker who gets the phone call for a listing that is $3,000 a month. And someone, whether they're a tester, a prospective tenant, calls up and says, well, I have a voucher for $3,000 a month. In that instance, you should, and the owner should not be asking about credit, asking about income, and rejecting a tenant based on any of those things would be discrimination. The government is already assured that this person has the income to pay the rent. Um, if the tenant is paying a portion of the rent, based on what their voucher covers, credit and additional income can still be considered on a case-by-case basis. But Division of Human Rights has said, you need to be careful because if the landlord's going to apply a minimum credit score that would prohibit anyone with a voucher from getting that apartment, that's discrimination. Um, you have to understand, these voucher programs, even if they're only going to cover a portion of the rent, they've typically, in almost all circumstances, kind of vetted a maximum rent that the tenant can still apply for, and they've already determined that the tenant has sufficient income to cover that portion of the rent. So again, if the landlord's going to require things that go above and beyond, they're really putting themselves at risk, because often the person that has the voucher, the reason they have it is because they don't have a credit history. They don't have a substantial income that's going to, and why would they? The voucher program saying their income is enough to cover their portion. We, the vouchering agency, the state, whoever it is covering the rest. The voucher programs often, they know. Somebody asked, Lori asked about utilities. They've assessed that. They've assessed what the tenant can afford. And the tenant has provided them that documentation. So you should ask the vouchering agency and or the tenant to provide that information they gave to the vouchering agency to show that they were able to pay their share or the utilities. All right. I know there are still a couple questions in the chat. I encourage all you, please take a look at our website, not only lirealtor.com, but Home for All of Us, because there is a lot of information there about lawful source of income. I don't want to get hung up too long on this. I need to move on to a couple other topics. But please take a look at the website because a lot of the things that I was not able to cover in full detail are covered there. All right, so I do want to just reiterate this warning on cold calling. I've given this in the last couple of classes that I've taught. You should all know that cold calling in New York is not permitted under a declared state of emergency. It's been this way for about 6 or 7 years. Believe it or not, in New York, we are currently under three separate states of emergencies. They probably will be extended. Maybe not the winter weather one, because I think, fingers crossed, we're beyond that now. But unfortunately, these states of emergencies are very easily extended by the governor. And as a result, no one in New York is permitted to make unsolicited phone calls or text messages to members of the public that they do not have an established business relationship with. All other kinds of marketing is allowed. So, this question, I've added this slide recently because I've gotten a lot of questions. Well, what's an established business relationship with? Established business relationship means did you have a purchase or transaction within the last 18 months with this person? If so, you have a relationship with them, you calling them, not a cold call. So if you had a listing agreement, a buyer representation agreement, a closing with that person that occurred within the last 18 months, you can certainly call them, no issue. Um, if they made an inquiry, they had an application, let's say they met with you, they filled out an intake form, maybe your open house sign-in sheet has something in there that says you consent to me calling you at this number, and it's within the last 3 months, not a cold call, right? Because they've inquired of you to conduct business. That's not a cold call. Anything else technically is a cold call. So if you're calling another broker's expired listings, you're calling a FISBO to try to get that listing. If you're calling them with a prospective buyer, totally different. Fine. That is you're trying to engage them with business on behalf of someone else. Calling leads that you paid for, that is not an established business relationship. Um, Joe, good question. Joe says, what are NYSAR and LIBOR doing? This is a distinction that isn't correct, that there should be a carve out for real estate. Um, Going to get to that. So the reason I'm just giving this warning is the fine if you violate the law is stiff. It's $20,000 per call. I don't think Department of State is going out and kind of trying to find cases where people are breaking the law, but if they get a report, they're going to investigate it. I mean, they have a statutory obligation to investigate it. And they have. And there have been instances where Department of State, based on complaints from the public, and because all of you have a license that comes from Department of State, it's Department of State, their Consumer Protection Bureau, that's going to look into this. Um, so there's a risk. There's a real financial risk. And you could see in one case what they sought from a licensee, $13 million. Um, it's a risk, and it's a terrible law. It should be changed. NYSAR is lobbying to get the law changed. There was a just January of this year, the Assembly did pass a NYSAR supported bill that would amend the law and really just make sure that the restrictions only in place um, for certain states of emergency, and that really trigger the need to block telemarketing calls, so that we get another Superstorm Sandy. That that's a legitimate emergency, and that's why this bill was passed originally. The law was passed originally. It's because you had insurance adjusters and contractors calling up people whose homes were just wiped out, trying to get them to basically do business right away. Um, so there is a push to get this law changed. There's been a push. I know some people will say, that like why hasn't this been changed sooner? Um, it's hard for a legislator to stand up in Albany, right, and say, I want to change a law that's going to allow for more cold calls. I, Generally, the public doesn't like cold calls, you know. So there has been a push. I'm hopeful that this legislative session, I encourage you when there's a call to action, to get involved. If you can and sign up, if you're a member of our Government Affairs Committee, head up to Albany for Lobby Day in April, and let our state legislators know that this should be changed. That sure, there are certain types of telemarketing during a legitimate state of emergency, but really, is someone not interested in selling their house because of overcrowding in a jail? Like, there's just no connection right now between the law and the reality. So please get involved. Voice your displeasure to our state representatives that this is a law that needs to be changed. Absolutely. I will say, once the law is changed, there are other restrictions that are in place. They kind of haven't gone into place yet because we've been under this cold call restriction for so long. Um, so make sure that once the restriction's lifted, and I can tell you LIBOR and NYSAR will let you know, once it is restricted, once the restriction is lifted, there are things that need to be done. There is a new law that requires you within the first 30 seconds of a unsolicited sales call to state your name, identify your company, disclose the purpose of the call, reveal if the call is being recorded, and offer the call recipient the option to be put on your company's do not call list. And if you don't do these within 30 seconds, guess what the fine could be if somebody reports you? $20,000. So I don't expect this to get changed. I don't expect them to create an exemption for real estate licensees. Um, but I'm giving you this warning because clearly there's a push at the state level. I don't think cold calls are really well liked by the legislature. And so you really, I'm not saying it's not a good business practice once it's permitted, but you need to make sure you're doing things the right way, so that you don't put yourself at risk for significant fines. A couple other quick issues I just want to talk about. The use of attorneys for closings. Not so much an issue here, but upstate, NYSAR was recently made aware that some licensees were telling sellers and buyers that, you can use a closing company instead of an attorney for closing. And in those instances, that closing company was not providing an attorney. They were just using paralegals to complete paperwork and attending the closing. I'm just going to let you know, if you hear someone down here make that recommendation, I would not follow that. I would not recommend the use of a closing company if no legal representation is provided. You have to act in the best interest of your client. And I think you should always strongly recommend that they retain an attorney to represent their interests. I think it protects you, it protects your client. And I think that if you don't make that recommendation, you could be in breach of your fiduciary duties. And you certainly should not be providing those services. Those are services, they're legal services. You could be subject to discipline by Department of State. You could be subject to, potential criminal penalties for unauthorized practice of law, code of ethics violations. So please make sure that this is not a practice that you are either engaging in or recommending. Brokers obviously could face liability as well. All of these things that I talk about, brokers need to be concerned about because, as I said at the very beginning, it is the broker's listing, and the broker has that duty of supervision. Another warning, just to make you aware of from Department of State, has to do with artificial intelligence. AI is great. I want you to all use it. I think you should all get trained on how it can be used because it's fantastic. And I'm not just talking about Chat GPT. There are so many things out there that can be used and have great capabilities. But with those benefits come significant risks. The accuracy is certainly a problem. I was just trying Chat GPT yesterday to create something having nothing to do with work, but just something, a kind of an image, something with my house that my wife was trying to redesign something, and it just it wouldn't do it, and it kept telling me it was doing what I wanted, and I finally said like you're misleading me, and it said yeah, you're correct. I'm not doing what you asked. So it doesn't always tell you it's not accurate, and it gives you information it knows isn't accurate, which it's really disturbing. Um, I'm not going to get into all the fair housing implications, but you could use it just to write a simple listing description, and it may, without you reading through, not realize, well, it indicated this property is great for families, or it's in walking distance to a church or a synagogue. It's, you know, Shira just points out it can be biased as well, right? Because it's pulling from a pool of information that has built-in historical biases. There are a lot of risks and considerations, so you need to make sure it's being used carefully. Um, Also for things like advertising, if you're going to modify images, it can make unintended changes you didn't ask for. So DOS, Department of State, they've acknowledged there's no law on the books that regulates the use of AI, at least in New York. But we have all these other requirements or regulations in New York that prohibit or regulate certain things in advertising. And all of those would apply to AI. And that was one of the warnings that Department of State gave that, look, you have an obligation to be honest and accurate in depicting the property and not to mislead the public. Department of State said, hey, and this is from the Secretary of State, and this was a warning that went to all of you back in November. So if Department of State's going to take the time to send a warning to every one of you that has a quote from the Secretary of State, I think it's safe to say this is on their radar, right? This is something that they are looking at, and that's why they're urging you to be mindful when using AI. Don't rely on it completely. Make sure I say a couple things. Brokers, I recommend you have an AI usage policy in your office. So at least you could point back to it if an agent misuses it. Um, have protocols, review everything. You cannot just simply go out and rely on what AI does. Again, I was using it just to make some visual kind of depictions of what putting a different couch in a room would look like, and the picture I got back eliminated an opening in a wall and moved the location of a window. I didn't ask AI to do that, but it did. So if you're using it to stage your room, you've got to really look carefully and make sure it didn't make any other changes to that room. It does it and it won't always let you know. Certain programs are better than others. So that's why I tell you, make sure if you're a broker, have a list of approved AI tools. Discourage anyone in your office from just going out and using whatever they think works because some of these tools are better than others. A lot of money in developing a good solid set of tools, but make sure you're using good tools and not some of these free off the shelf apps that frankly don't do a very good job. Couple other things, don't use it for contracts and legal advice. I can tell you, I've kind of from time to time toy around and put things in there to see what it comes up with. And it looks really good. You get output. Give me a contractual provision that says that covers the following. Looks great. It may not pass muster in New York, but it just looks great. It sounds great. It sounds like a lawyer drafted it. You can't use it for those things. Just last point on enhanced images. You can use AI to stage rooms, enhance images, but you always want to provide both the original and altered image, have them side by side, have them available in whatever advertisement. I would strongly encourage you to caption those photos. If you're a broker, have a standard caption that you want your agents to use when they are advertising enhanced photos. Um, don't misrepresent the property's core condition. No hiding defects. Again, my warning is some of these programs, they think they're doing you a favor. They think hiding a defect is what you want. And you can't do that, right? You can't mislead or change structural elements in a property. So just be careful. Ensure transparency. You always want to make sure that the buyer is not being misled, or anyone, a consumer, a member of the public, is not being misled and expecting something dramatically different in person. I make this warning just because Department of State did it. And if they took the time to put the warning out there, I think this is something that they are looking at, and they might not take lightly if they get a complaint about it. All right, so I'm at the end of time. Thank you for your questions. Thank you for your attention.